Okay, so we're gonna get started with panel one, and before I do that, I just wanted to make sure to give a round of thanks to Shop and the whole IT team at Temple that has really also helped to make possible and here exhibit of the IT team at Temple. Okay. Okay, so I just wanted to start off with a round of introductions about all the panelists. So our first panelists today are going to be, so we're starting with Mital, Lyons-Warren, who is a specialist on economic opportunity and financial empowerment team at the Institute for Youth, Education, and Families. She transitioned to local government policy after 6 years working in criminal justice reform and is now focused on the racial wealth divide, fines, fees, and equity, economic mobility, and youth civic engagement at the National League of Cities. With her is Denise Belser, who is a program director of the Economic Opportunity and Financial Empowerment Programs at the National League of Cities, Institute for Youth, Education, and Families. In this role, Denise works directly with cities to promote economic inclusion and increase access to public benefits. Denise began her career in the financial services industry, working in both the nonprofit and private sectors, including serving as a founding manager of Seedco Financial Services, focusing on access to credit and innovative small business lending programs nationally. Then our second presentation will be Paige Joki, who is a staff attorney at the Education Law Center, where she represents students, conducts training, and advocates to address individual and systemic educational barriers facing students in Pennsylvania. She's responsible for leading ELC's Black Girls Education Justice Initiatives, and she joined the staff in 2017 as an independent foundation fellow with a focus on eliminating barriers to quality education for students experiencing homelessness in Philadelphia. She's also a Temple alum, yay. And with Paige is going to be Thalia Gonzalez, who is a senior scholar at Georgetown University Law Center in the Center on Poverty and Inequality and a professor of politics at Occidental College. Thalia's teaching and research focuses on restorative justice, gender justice, health equity, public health law, education law and policy, juvenile justice, and critical race theory. She's the author of more than 34 academic publications, including a recent research publication in Stanford Law Review Online, Journal of Law, Medicine and Ethics, American Law Review, as well as the Bill of Health at Harvard Law School, examining the use of school policing and exclusion through anti-racist health equity lens. Presentation 3 will be by Kay Greenberg. Kay Greenberg graduated from Temple Law in 2011, another yay, where he was a Beasley Scholar. He worked as an assistant PD in Philly from 2013 to 2018, and then left to join Community Legal Services Housing Unit. As a member of the housing unit, he primarily provides same-day representation to tenants through the Philadelphia Eviction Prevention Project's Lawyer of the Day program. And last but not least is Kathleen Noonan, who's going to do presentation 4. Kathleen is the Chief Executive Officer of the Camden Coalition of Healthcare Providers, a nonprofit healthcare innovator that recently launched the National Center for Complex Health and Social Needs. In 2008, Kathleen co-founded the Policy Lab at Children's Hospital of Philadelphia to connect clinical research with real-world health policy priorities. She had a BS in psychology from Barnard College and a JD from Northeastern University. I just want to say a few brief words about this panel. All of our panelists work in the trenches on these fundamental issues like economic instability created by government fees against the poor, access to education, quality of housing, and other legal issues that ultimately impact public health. What's most impressive about the work of these panelists is the way in which it challenges age-old what we consider natural, right? It's just the way that it is, or that we somehow live in meritocracy that provides for a level playing field. Rather, their work shows us how the corrosion and coercion of existing policies and practices are endemic to the structural inequality and racism, and what one can do about it. So with that, I turn it over to Mital and Denise to start us off.
Thank you so much. Good morning, everyone. It's great to be here. So hi, I'm Denise Belser, and it's a pleasure to be here with you today, although virtually. Mital and I very much appreciate being invited by the Temple Law Review and the Center for Public Health Law Research, and look forward to today's important dialogue. We're part of a team at NLC that puts financial health of families front and center every day, believing that cities are stronger when its residents can thrive and participate in an inclusive economy. Financial instability is detrimental to an individual and his or her family's life trajectory, creating barriers for housing, employment, food access, medical care, and mental well-being. One promising way cities can increase economic opportunity for residents is by examining policies that decrease household debt for low to medium income families. This is especially true in recent years as cities have advanced sophisticated financial empowerment programs that expand access to financial coaching and life-saving benefits, especially for families that are struggling to make ends meet. Too often, these same cities have departments and court systems that create unintended consequences for some of the most vulnerable groups in our society in the name of justice and to balance operating budgets. For example, unpaid fines and fees can quickly snowball, leading to escalated fines, driver's license suspensions, or even jail time, all of which further impede residents' ability to repay by making it more difficult to maintain employment. At the National League of Cities, we see this as a missed opportunity that warrants new thinking. Over the last 7 years, we've partnered with a handful of cities to tackle this issue. The first was a water utility debt program called Lift Up, which offered cities a framework to weave a set of holistic interventions throughout the water billing and collections process. The second program that we're looking at is tackling municipal debt more broadly, called CAFE, which stands for Cities Addressing Fines and Fees Equitably. Through CAFE, we see the need to center racial equity in reforming fines and fees in all areas of city government, not just water, but also traffic, towing, probation, etc. And as we now know, the impact of these fines and fees disproportionately affects residents of color, while also creating more municipal debt for the city. It's been an interesting journey as we learn more about what cities have authority over when it comes to reforming different types of fines and fees. And we see promising opportunities, especially for court systems, to eliminate biased fines and fees and to enforce necessary ability to pay rules. I'm going to turn it over to Mital to share some insights, and I am certainly looking forward to the panel's continued conversation. Thanks.
Thank you, Denise. So again, my name is Mital, and so through our CAFE cohort, as soon as the city validates that fines and fees are an issue for them and their residents, assessment is really the next step in addressing these fines and fees. And CAFE was designed to help cities build that financial capability of its residents. So a connection to financial empowerment programs and services is a crucial element of the process. And for cities to know who to target for financial empowerment services and which fines and fees to reform, they can assess and analyze both quantitative and qualitative data to gain insight on where the pain points are for residents, and definitely disaggregate by key demographics like race and gender. A central piece of the assessment process is understanding who is most impacted by certain fines and fees. In our inaugural cohort of CAFE, NLC expanded to engage municipal courts in addition to mayor's offices. Both Aurora, Colorado and Baton Rouge, Louisiana joined as full court teams. Municipal courts, as Denise mentioned, have a significant role to play in disrupting the cycle of debt for residents. And we see tremendous opportunities for courts to pilot reforms, like ability to pay and financial coaching, and decrease inequities municipal debt is compounding. We chose to look at data for Aurora, Colorado because of the budding opportunity for not just the city, but regionally and across the state to implement financial empowerment for all residents. So utilizing public census data, we developed an algorithm to simulate the impact any fine or fee would have on a household, and in doing so, identify social and demographic characteristics of families who would be impacted the most. The analysis showed an interesting finding for a hypothetical $150 fine. 15% of households would be overly financially burdened by the fine, meaning the fine potentially triggers a cycle of debt due to low disposable income. Hispanic and African Americans were overrepresented in the sample, along with other vulnerable demographics, including seniors, children under 18, renters, and people with an average monthly disposable income of $42 after rent and utilities. You can see graphics representing these statistics in our resource packet, and you can also check out the whole entire story map linked within the document as well. After confirming which fines and fees are pain points and who is likely to be impacted the most, there are three main reforms for fines and fees NLC has recognized through our work: eliminate alternative methods of payment and ability to pay determinations. Ability to pay determinations are a formalized process of determining the ability of the responsible party to pay the debt owed, and it can result in a reduction of debt, a waiver or suspension of that debt, extension of the time to pay, or elimination completely of the debt owed. Although both the American Bar Association and the National Task Force on Fines, Fees, and Bail have recommended ability to pay, formal pay models are not common at the local level in either courts nor municipal departments. Anecdotally, we heard from courts and judges that refer to themselves as kind courts by waiving fines and fees regularly, but with no prescribed process. As well as some municipal departments might have a sliding scale for some city services. When ability to pay considerations are not consistent, the likelihood of unconscious bias increases, and imposing fines without an evaluation of a defendant's ability to pay is counterproductive and harmful, especially when residents municipalities are engaging with are already historically disinvested in and compounding other intersecting oppressions. We predicted in our simulation that when the $150 fine was cut in half to $75, the burden of the fine would decrease. We saw this in the number of residents who were only lightly burdened, 0 to 20% by the fine increased, while the number of more severely burdened, low to extreme, or 20 to 100% group significantly decreased. Again, these results can be seen in our packet. As we continue to evolve the best solutions with city leaders, we know debt intersects with many people's lives. The impact of COVID-19 has exacerbated fine and fee debt, medical debt, student loan debt, housing debt, and much more. As you will hear from our fellow presenters, these inequities existed prior to the pandemic, and with historical funding from the federal government and revitalization and advocacy, significant change can happen. Thank you so much, and we look forward to the conversation to come.
Great, so let's go on to our next panelist, which is Paige and Thalia.
Paige, do you want to share the screen if possible?
Yes. Good
Great.
morning. It says that host disabled participant screen sharing. Is it possible to get screen sharing ability? If not, we can work without our visuals if needed.
I think someone's looking into it.
Well, as that happens, I'm happy to go ahead and jump in. So we want to thank everyone for having us here virtually, especially since Paige and I work on two different coasts. I'm in Los Angeles and she's obviously more local in Philadelphia, but it's a really wonderful opportunity to have a conversation about how we should understand and construct school discipline and school policing, and then really the extension of what that means when we're moving outside of the school context and beyond. So to do that, since we don't have slides to share, I just want to give, oh, here we go. I want to give a little bit of context here. As we're talking about this and we're thinking about education, there's a couple different ways in which we'll enter into the conversation. I first want to acknowledge that when we start to talk about education as a social determinant of health, there is a framework in which our work situates, and it's what's this really powerful and significant framework called health justice that has emerged first in Emily Benefer's work back in 2014, and now very significantly beyond. And the reason that I want to spend some of our precious airtime mentioning health justice is because it's not just a framework or theoretical approach, it's actually about how do we think about the practical applications to target law and policy to eliminate health disparities. And to do so, what health justice scholars and practitioners do is to place subordination at the center of the problem of health disparities. And what that means is that you can then embrace a much broader conceptualization of what discrimination is. So it's no longer, well, what do the courts recognize as bias for legal remedies? It's also all of the actions described in discrimination, the bias, the unfair treatment in public health, right? The ways in which we might not have previously thought of something as legally actionable under a court-based approach, but as we start to elevate the ways in which racism and social control and bias and privilege, as well as the political and legal system in which they exist, then we have the opportunity to think about this from a reformist standpoint. And actually, I would argue that to think about bringing a new set of claims, which is actually what colleagues have done and argued for, including Angela Harris, in a civil rights approach to health. And so why would I spend time talking about health justice? Well, because whether we're talking about the case of school discipline and policing as it exists in a school context, or as today's conversation will move us beyond the school context, it really is a two-step approach. First, it's about putting it within the context of public health law and health law. And then it's thinking about what are the legal and policy interventions that are very structural, supportive, and empowering. Because at the end of the day, health justice is not about reifying the existing subordination. So if we're thinking about conceptualizing education laws and policies in a health justice framework or as a matter of public health, right, by extension, then we want to think about education as a social determinant of health. And that was the previous slide that you saw before you. So how is education a social determinant of health? But more importantly, what are the relationships between the school environments and health? It's either going to be a strong predictive factor for positive health outcomes, as we see on one side of the slide, or for negative health outcomes, both at the individual and community levels. And that's true not just for young people, for students, and thinking about how your health can either influence by diminishing your educational attainment or reducing it, but what health means then as you think about the relationship between school environments as setting a healthy framework for the totality of future, or as school environments, especially in the digital age, have moved into what we call our home environments or our community environments. And that's a really central aspect of it. And so as we're moving through this conversation, I want everyone to be thinking about a set of questions. The first one is, okay, well, what is just the relationship with education and health? And we see that asserted here. But then are there these patterns about disparate outcomes and educational experiences that are really landing on specific individuals and populations that put them at risk for greater health outcomes? Or more directly, how can we think about discipline and policing in the schools and policing outside of the schools that is being experienced in a disparate manner when we compare groups? And at the end of the day, right, the very clear response to that is that BIPOC students in particular and their families, and if we disaggregate that even more and we think about the role of racemes, it's actually Black students and Black families that feel this most definitively. And so there's this clear evidence of the ways in which these disparities across all measures of data are actually creating a compounding effect. So to the next slide, Paige. So this is then where we start this conversation, but it's not where we're going to end this conversation, because this is how we can start to reconceptualize through a health justice framework why and where we must address policing and discipline as a health justice issue, as an educational justice issue, as a civil rights issue. Because when we look at these 5 indicators, and this is actually a meta-analysis that we've done in previous work, we can be able to see different categories of outcome, whether it's diminished educational attainment, whether it's impacted mental health, whether it's diminished health protective factors, physical violence, or risk of justice system involvement. But it's not just this that we have to be concerned about when we're talking about the relationship between discipline and policing in schools, and the health and mental health of young people. It's also about how and where is just the mere presence of those individuals and those practices and policies that create a dose effect, meaning those who experience higher level exposures to both of them are ultimately going to bear the biggest burden of disparities. And likewise, their parents and caregivers are more likely to also experience a dose effect and have a negative co-influential relationship. So you can consider a quick study that occurred most recently, was published most recently by a Harvard professor who was looking at the ways in which students who attend schools that receive federal funding with school police are less likely to graduate from high school, enroll in college. But taking that one step further, that the risk of exclusion, thinking about something relative to discipline, is not just lowering academic engagement, it's also fueling the school to prison pipeline and school push out. And so when we then look at that from a data standpoint, it can lead to an increased risk of push out or dropout, depending on the language in which you want to construct this, which is more than 10%. And again, disproportionately, given racism and given anti-Blackness in schools, we see that the effect is most significantly affecting Black students. And then when you layer in racism as its own determinant of health, on social determinant of health, on youth health, and on adult health, we see all of the measures start to push this even more significantly. So again, it's important that we understand discipline and policing in and of itself in the schools as a health issue and as a critical issue of health justice. But now we have to then think about what this means outside of the school context. And this is where I'm going to turn it over to Paige, that where we're thinking not just about the consequences relative to health symptomologies or risk factors, but what these education policies and practices do to move this into homes, into communities, and land not just on one set of group bodies, but really a totality of community health harms, and why the implications are so great, and that we really have to start to pay a significant attention.
So good morning. It's a pleasure to be back virtually on campus. I want to talk about nationally and in Pennsylvania in particular, 3 types of education laws that enable the impact of school-based policing to spill into and bring health harming effects into our communities. So I will be talking about residency investigations, which enforce who goes to school where, which preserve tightly held boundaries of racially segregated schools in Pennsylvania, attendance laws and actions, also known as truancy, which enforce the requirement that young people ages 6 to 18 in Pennsylvania attend school every day and follow school rules. For the sake of time, I will answer questions about this, but I don't have specific slides. These laws allow the arrest of students who don't attend school when they're in community, authorizes the imposition of fines and jail time for families who are impacted, and also allows referrals to child welfare agencies, including up to removal from the home for not being able to attend school. And lastly, we'll discuss parental exclusion notices, also known as parent bans, that govern parents' interactions with schools and their presence physically on campus, which limits families' ability to interact with the school, and can involve the threat of arrest or actual arrest for parents who don't follow the terms of the notice. And so the first is residency investigation. So generally, with some limited exceptions, people can attend school that serves their catchment, which is the area that feeds into the school district where the child is attending. And these laws cause Black and Brown students to be educated in underfunded and segregated schools. Today is actually a very important day for Pennsylvania school children because a fair funding trial kicks off today. And Education Law Center and Public Interest Law Center are litigating for ensuring that our schools are fully funded. And a fact that not everybody knows, but that's a very important context, is that Pennsylvania actually has the most economically segregated schools in the country and some of the most racially segregated schools in the country. And so residency laws reinforce educational deprivation stemming from substandard school conditions. And it also incentivizes the use of investigations to inquire about whether a particular child has a right to attend a particular school. Schools can then collect tuition for violations of residency laws if a child attends the school without a legal right to do so. These are described as theft of services or falsification on a sworn affidavit, and they can result in massive fines for families that then go right back into the school's budget conveniently. So the investigation of who belongs in a school is racist and is a tool of white supremacy. So investigations themselves often begin with an uncorroborated tip about who attends school. So it could be somebody calls the office and says, I'm not certain that Paige actually lives in this area. I think you should check her out. Literally, that is the extent of some of the information. And so the tips are often racialized, like you don't look like you physically belong because you're a Black person. So usually the student is Black or brown, doesn't look like they belong in the district, which is typically hyper-segregated, white, and affluent. Police are often involved in residency investigations, but even if they're not directly involved, schools use tools and rely on practices utilized by law enforcement to effectuate residency investigations. So at Education Law Center, we have seen the use of invasive investigatory tactics that mimic abuse that families have survived. So I have seen elementary students be slow followed in cars. Families that are residing in hotels because they're fleeing situations of violence are being awakened repeatedly in the night because the school's calling to verify that they're still there. There has been prolonged surveillance operations and stakeouts of students in person, by phone, and through the use of law enforcement technology called CLEAR, which boasts that it helps to find hard to find information and public records technology to quickly identify concerns with people and with businesses. So this is the actual software that law enforcement use to tail people. Schools do it also. And even if police or others are involved in residency investigations, they treat them as if they were investigating a crime. So they might show up in uniform, they might show up armed, they might talk to everybody around, they might request people make formal statements, and oftentimes they request that they are signed. And they often threaten, if you lie to us or you don't cooperate, you could be put in jail, which is really scary for families. So the impact of these laws are great. It exposes families and surrounding community to interactions with law enforcement and the criminal justice system. It reifies and reinforces boundaries that were created by segregation, both racial and economic. And it frustrates and diminishes school attendance because it results in families not sending their children to school out of fear that they'll engage, that they'll have to survive these abusive tactics on the way to school, which opens them up to truancy prosecution. And it can also result in schools enrolling the children, but not actually allowing them to attend school. And then the school refers them to truancy proceedings, which is terrible. The next thing I want to talk about is the issuance of parental exclusion letters. So parents and caregivers actually do not have a legal right to be on school grounds, and they can have their ability to show up limited by schools if they are deemed to be a threat to the school community. And threat is very broadly conceived, as we'll get to in a moment. So Education Law Center has responded to parents being banned for things as simple as the school failing to provide guaranteed special education services that a student needs to access school. So parent will show up and say, please implement my child's individualized education program, and they'll be banned for doing that. Ignoring environments that are toxic to students, full of bullying and harassment, and refusing to address behaviors by staff that physically harm students, such as the unlawful use of restraints, which is when adult staff put their hands on children in order to stop their movement. Most often, we see Black mothers being banned for undertaking important self-advocacy against the education civil rights violations survived by their children. So once parents are banned, their ability to participate in their child's education is significantly undercut. We have seen notices that are indefinite in time frame preclude parents and caregivers from participating in important school events like parent-teacher conferences and special education meetings like IEP or 504 meetings. We've also seen families who have children who are various ages at school not be able to drop off preschoolers and have to send them across the street because they weren't allowed to be on campus without a prior appointment. It also cuts off key ways to resolve disagreements without legal intervention, and it exposes students and caregivers to arrest or interaction with law enforcement if they show up without an appointment, even if the schools refuse to set up the appointments that they require parents to have. And so we see that this creates a very unwelcoming environment for students and families, and it bleeds into communities because these notices are widely understood to be tactics used in the Philadelphia area, and parents, often Black mothers, can come to expect that throughout their trajectory with their children's school that they can be banned, which is certainly not the educational environment that helps kids grow and thrive and feel celebrated. So I'm going to turn it back to Thalia for a framework for action.
So really the question then becomes, well, what do we do, right? If we know that whether we're talking about in the context of schools with policing and discipline practices or outside of the school context, and still placing this within the bigger historic and contemporary framework of subordination and racism, and in particular knowing that the differences in chronic exposure discriminatory experiences, exactly what Paige is talking about, increases your allostatic load. And that increase of allostatic load is heightening your risk for health outcomes, or is actually creating negative health outcomes in itself, then what is the way in which from a more holistic standpoint we can think about acting? One is through medical legal partnerships. It's an emerging area within the context of legal education. So this is something, especially from an academic standpoint, what is it to infuse our curriculum with a multi-stakeholder approach, with an interdisciplinary understanding of the ways in which exactly what Paige described as civil rights violations are also public health threats. And so a medical legal partnership is going to meet both the medical needs and the health needs of a young person or a family going through that process, is going to conceptualize the fact that, you know, a parent who receives an exclusion notice or a young person who is being considered truant, and then that's implicating the family, or policing is happening at school and they're experiencing violence, and then their parent is trying to come advocate, they're going to do a totality of look at that both through a medical lens and through the context of a legal lens. Absolutely bringing in the voices of those that are most impacted. Advocacy and research, while there's been attempts, is still not really thinking about how are the ways in which those with the most expertise, the most impact, can help craft what the solutions are. This comes back exactly to a health justice framework, because the third prong of what health justice requires in operationalizing targeting relative to making change is that it uplifts, and not just uplifts, but deeply integrates what is lived community experience. And that's different from a traditional legal perspective, as much as the ways in which as lawyers have worked and tried to develop more and new rebellious, democratic, community-centered approaches. Public health is grounded on a participatory framework, excuse me. And then what is it to think now about education laws as legal determinants, right? That education laws in and of itself are causing health outcomes and creating deleterious effects that are following young people through the trajectory. And so where and how can we look at education laws that are health affirming and start to invest more significantly in those, or develop new laws and simultaneously reduce laws that are health harming, right? And I think that we've given you some examples, and definitely Paige has given you some very clear examples in your own backyard of where that might be. And then lastly, it's about that cross-disciplinary relationship, right? What is it to bring together a set of stakeholders from different areas of expertise, not just from a deep community lived experience, but also from public health, from health law, from education, to have a more complex question and response, right? What is that dialogic moment? But more importantly, to recraft what these laws and policies are, or ultimately to dismantle these laws and policies. So let's have clarity that is not just simply about fixing a broken system. This is a system that is working in the way that it was intended to work, right? It's working in a way to ultimately promote subordination and social control. But now, how do we dismantle that and replace it with a system that is not only health affirming for young people while they're in schools, but really is health affirming for communities and parents and caregivers that are outside of the school context, to ensure the totality, not just of that young person's well-being and thriving in life, but community well-being and thriving in life. And with that, we realize we are probably over time, and we will absolutely yield the floor and think about what conversation is at the end.
Thanks so much. So now let's turn it over to you. Hi, I'm Carrie. I use the pronouns. Thanks everyone for presenting. I'm officially angry and didn't even get coffee so far. So I'm here to talk to you all about housing, and specifically public housing and the impact that it has on family separation. Now, I'm kind of thinking about this through like a public health lens, which isn't necessarily my typical lens. I'm kind of struck at that this is an ironic point at which to be discussing health and housing. during the COVID-19 pandemic, because it's pretty hard to shelter at home if you don't have a home to shelter in, which is the thing that faced many families in Philadelphia. So I think that is, I mean, a clear impact of housing and on health and just. So I wanted to kind of talk mostly about the Philly context. I'm going to briefly go through some of the laws and the evolution of public housing, just kind of touching on things, not necessarily everyone that's been passed, but the important things, and then talk about essentially how these have played out in family separation. A lot of what I'm going to be talking about is anecdotal, just based upon my experience in court. I represent a lot of families who are being evicted from PHA housing, specifically on the basis of criminal activity. Philly Landlord Tenant Court, in case you aren't aware, has been up and operational since September of 2020. So they started bringing people back to court since September of last year. However, people weren't actually able to be physically removed from their homes until the moratoriums that just recently ended. So basically, at this point, they're now dealing with a backlog of evictions that have piled up. During this time, PHA agreed. When I say PHA can also mean generally housing authorities, but I'm referring to Philly, and I'll try to make it clear when I'm not. All right. So basically, PHA agreed and has not brought cases for non-payment of rent. However, they have received cases for breach, meaning that a part of the lease has been broken, and one of those breaches has been criminal activity. So just in talking about public housing, there are many different types of federally subsidized housing. Specifically, what I'm talking about is those that are owned and operated by PHA. I'm not just talking about stuff in Section 8 and things like that, other federally funded programs. And kind of why I think I touched on this earlier, why I chose to deal with this topic. It's something that I just kind of see, and it seems like a good opportunity to talk about it. I mean, I see the results of what other families are talking about in my work. People who are denied admission to public housing on the basis of the criminal records. I'm going to expunge them. I can't expunge them because there's outstanding court costs and fees, which stop the expungement. So all of this stuff that we're talking about is it's intersectional. So it's good to talk about this all in the context of the criminalization of poverty and the ways in which these all interrelate. Because anyone who does policy work knows if you don't have numbers, the problem doesn't exist. So luckily, at Penn Student, Erica Rodarte, who her article on the subject section published this spring, collected data and finally allowed me to share it with you all in advance of her article being published. So she's studying the cases that have been filed by PHA on the basis of criminal activity from 2011 to 2020. She did find that since 2015, there's been a drop off in the number of cases on the basis that have been brought on the basis of criminal activity that PHA is pursuing. Now, I'm just wondering if maybe you think it would work better if you spoke getting messages to folks who can't. I just wanted to make me stand up and do my exercise this morning. All right. So back to facts and figures, those are exciting. Those 648 cases, 216 of those cases ended in judgment by agreement. What a judgment by agreement is where the two parties come essentially to an agreement that either will result in the person maintaining their housing under certain circumstances, or give them a certain time frame to leave, establish things like money is owed, anything like that. It is a judgment. When these are entered into, their judgments against the tenants, they're on the record. Luckily, Philly just passed the Renters Access Act, which mitigates some of the issues with these judgments by agreements. And in studying these cases, she found that 216 of these cases ended in judgment by agreement. So a third of the 648 cases that were filed on the basis of criminal activity, a third of them ended in judgments by agreements. And the judgments by agreements, what the tenant agreed to do to maintain their public housing was 52 people agreed to some form of family separation, meaning that they kicked someone in their family who was related to criminal activity out of the house and off of their lease, or 60 people banned a person from the property. 30 of those were a direct family member, 30 of those she found it was unclear exactly what the relationship was. So that's, for example, if fathers are unable to come visit their children because they've been banned from the property, siblings unable to visit each other, that's what that a ban means versus an eviction. So how did we end up here? So the laws that relate to public housing, as you're probably aware, are federal. There's the promulgation of the federal code, but then each PHA, each city, then has its own admissions and continuing occupancy plan. And the federal guidelines leave a lot of room for discretion for the local public housing organizations. So while this is a problem of national coverage and of national law, there is considerable avenue to be able to work on it and create solutions on a local city level. So what we're dealing with right now, so in I said I'll do this as quick as I can, 1937, the Housing Act of 1937 essentially created public housing, at least the first kind of version of it as a part of a union program. What's important about this, the reason why I'm bringing it up, is at that point, the reforms and creating of the public housing was treated not as the use of public housing was not a personal moral failing, but as a widespread having housing provided was in answer to a widespread social and economic injustice. And then and at that point, the majority of public housing residents were white. It was the way of housing and then it was a way of dealing with the result of the Depression. Right. Housing Act of 1949. So that changed things. There was more public housing money, but at the same time, there are also changes in relation to federally backed mortgages, which led to what we all know as redlining. So, so basically, the result of this act is white people started moving to the suburbs because they were able to own homes, lead to affordable mortgages, and the population of public housing and neighborhoods for housing, and also the neighborhoods in which the housing was built were primarily Black. And this is when the perception of those in public housing and access to public housing started to shift as we looked into, there was more of a focus, and the focus started to become not about providing housing, but also on getting rid of or keeping out the undeserving poor. And that is key to the dealing with the impacts of criminalization and family separation, because the idea that, well, if you don't deserve housing, then it's a privilege, not a right. It's literally something I've heard. So it's the idea that that it's about policing versus providing. And then something else that people are probably familiar with is the one strike rule. So Clinton said, if you break the law, you no longer have a home in public housing. One strike, you're out. That should be a law everywhere in America. And there were several laws through the 80s and 90s that were passed. But kind of the overall impact was that PHAs were now required to evict tenants from housing for drug activity honored at the premises. And in fact, under a guidance given by HUD in 1996, not only were PHAs given the power, they're actually incentivized, and they can be critiqued if they were not enforcing the one-strike policy indefinitely. Now, and this was enshrined in the case, the Rucker case, which the Supreme Court found that no innocent owner exception, meaning that owners are responsible for the actions of their guests or other family members, even if they don't know that something's going on, they can still bear the have to deal with the consequences of it and be evicted. I think I'm almost at 1 point. So, all right. So this is all right. Long story short, that's more outline, but let's just say long story short. All right. So basically, evictions are happening on the basis of criminal activity. PHA is evicting people on the basis of criminal activity. And this is forcing a lot of families to have to deal with this question that no one should have to deal with, whether or not, if my child was arrested in school under one of these circumstances, whether or not they kick that child out of the home and maintain their housing, perhaps for the rest of the family, or whether or not they allow that child to remain in the home and then will be likely evicted from the property. It is still the fact that the use of discretion is used more broadly rather than more limitedly. And that's basically, that is the quickest outline I can give of public housing and the impact of criminalization, but I'd love to hear the questions later on. Thanks.
Great, thanks, Kay. And we maybe go to
Thank you. Can you all hear? Yeah, great. All right. Kathleen, Noonan, thanks for having me. So I guess what I want to do is just ask you to think about a couple of questions. The first is, as you interact with large, very large, probably overly large health systems, I want you to think about how all those touch points of those health systems might be able to actually influence the criminal justice system. And then the second thing is that as you pass people, we all pass people on the street and wonder about them. I want you to think about the fact that they probably all have benchmarks and are likely to be, have a high likelihood that they could go to jail because of fines and fees. But what I also want you to think about is whoever it is you're buying your sandwich from, that they potentially have fines and fees and a bench warrant, and that they are actually very, very nervous that they could end up in jail as well. So these are the people that we're talking about. They're all around us. Okay, so the Camden Coalition is an organization we started about 20 years ago. We help people with complex health and social needs. We're really trying to demonstrate effective programs, but we're also trying to advance sort of bigger, not bigger, but better ecosystems. And that includes the health system and the criminal system and lots of all of those systems that make up a sort of healthy ecosystem. We started about 20 years ago with a social worker, nurse, and community health worker. We sent them out of the hospital and into the community. We put right from the beginning sort of 16 domains in front of them. We actually use cards, imagine Monopoly cards. We use cards to actually just talk about, what would help you feel better. One of our lead clinicians, I wish she was here, Janine Skinner, she actually asks people what brings them joy. And our clients are people who have multiple physical health issues. They have substance use issues, mental health issues. Many of them are on the street. And often when we use those cards, it becomes very clear to us that they are much more concerned about their criminal criminal justice issues than their health issues. In fact, the number one thing often is that they just can't get their IDs figured out and their paperwork, to be honest. So what we found is that we can really figure out how to create authentic healing relationships with people. We know how to do that. We also can figure out how to help people navigate the health system a little bit. But we could not help them with their fines and fees issues, just in that. And so what we did is we teamed up with Rutgers Law School and we created an NLP in 2018. It took us a couple of years to do it. It's not something that just happens like that. Our NLP, and I work with Children's Hospital Philadelphia, I do have experience with NLPs. Our NLP is very different in that we are willing to take on fines and fees issues, and we're also willing to have to partner with a criminal attorney. So I know, Thalia, you mentioned NLPs. Most NLPs do not take on fines and fees issues at the moment, and they are typically sort of reticent to deal with criminal issues, especially those NLPs that are hospital-based. There's a risk calculation that's done, and it's decided that they should stay away from issues like that. So our coalition, our NLP does work on those issues, and not only that, but our NLP actually, we embed the lawyers right into our care team. So the lawyer works with the social worker, the nurse, and the community health worker. And what we're also trying to do is train all those people to actually understand fines and fees issues so that we don't necessarily always need the lawyer, but that the nurse and the community health worker can actually go to court with people and be able to talk about those issues and why it's important that we work on a plan for them to pay their fines and fees, and also that they don't land in court. So I'm going to wrap up sort of quickly so that we can get to questions, because I'm sort of the person between like one round like that last speaker. But what I want to sort of leave us with is a couple of points. First, sort of thinking about what health systems can do. They can actually think about working with NLPs and letting NLPs actually work on issues that really are getting at people's health and getting in the way of people's health. This is as simple as, does everyone know what an EPIC, a health record, and an electronic medical record? This is as simple as actually creating an electronic medical record that just says, I understand that our client has fines and fees, and we just want you to know that these are the issues that they're working on, and that any kind of payment system that allows them to continue to be able to come to us for whatever health issue they're working on would be helpful, or something that says they've been compliant in terms of showing up at primary care. One of the things that we know for our clients is that the more they show up at health appointments, the more also that they are likely to be adherent to other types of things. So those are some of the things that they can do. On the criminal justice side, we really need to have criminal systems that actually pay attention to things like that, right? That people are actually adhering to some kind of recovery program, et cetera. So one final plug, we have a brief coming out about the way we approach fines and fees, and with our health team, Punita Padue is actually the lead author on that brief, and Don Berwick, if you all know him from health on the health side, actually wrote the forward to that brief, really encouraging health systems and health leaders to think differently about fines and fees issues. One of our clients is featured in that brief, Andre, and his story is a story that we hear all the time, so it's not unusual, of someone who is crippling fines and fees debt out on the street, not really even knowing, where to start, but by us really taking a very direct approach to the fines and fees, being able to work out payment, he's still paying them off, and work out the ability for him to also do community service to actually in exchange for actually the payment of some fees. So we actually think that a lot of this is solvable. We just have to use our resources differently. So I'll stop there. I have some questions.
Christina, we don't have that much time, so I'd actually like to open it up to the audience to see if folks have questions that they'd like to ask. Because I have a list of them, but I don't want to hear from me, so just wanted to see if.
People in the chat, it says, for Paige, I'd like to know more about the impact of the anti-certainty laws and the mechanisms of their enforcement on health and education outcomes for students. I'd also like to hear about disruptive methods for encouraging school attendance. I'm going to put it in the chat.
So this is a question for Paige.
Thank you. I can see it in the chat, so just give me a second to read it. Yes. So the first question is about the impact on mechanisms of enforcement of truancy for students. So what we know is that attendance as it's enforced today actually does not, truancy laws do not help improve children's attendance. And that is because families and children face systemic barriers to getting to school that are systemic in nature and are not about the student. Usually on the paperwork I see, it says lacks the motivation to go to school. And that's not the issue, right? It's that the bus doesn't come, it's that they won't be enrolled, it's that the school community is toxic to them because of conditions that the school is failing to remedy, or there are transportation issues, or there are a myriad of other things. But instead that gets distilled down to, why can't we get a student to school? And so what actually works is asking families what they need and doing a comprehensive analysis of barriers. So under Pennsylvania law, there are requirements to hold a school attendance improvement conference and develop a school attendance improvement plan, which is supposed to be a comprehensive system to identify barriers, something like the bus doesn't come or they won't enroll me. And so when the law actually works correctly, those things would be helpful. The problem with our law now is that they authorize a bunch of things that just hurt families, like fines and jail and separating students from families. And so things that work to improve attendance is making schools places where students actually want to go and not making them feel like jail. So if you are greeted every day, if your teachers care about you, if they understand if you're experiencing homelessness or food insecurity, or your family needs resources, those conversations help get children to school a lot more than come to school or else sorts of discussions in truancy. And there are also some really great resources. Education Law Center has a few on our website, and they're free, about how to address barriers to attendance more comprehensively. I just want to turn to Thalia. Do you have anything you would want to add on how to get children to come to school?
I was actually going to jump in on the first half of the question, which I think was, if I'm reading it correctly, directed specifically to thinking about what is the relationship between truancy and enforcement on health and mental health of students, and say a couple things. One, the limited data, because this is such an underexplored area and there's been a lack of attention for a whole host of reasons, research bias. One, truancy diminishes school climate. And there are studies that show in the context of reduced school climate, that it not just only creates feelings of negative school climate sort of writ large, it actually creates disassociation, depression, increases feelings of chronic stress and trauma. And then that then leads to movement out of the school context. So it creates a negative feedback loop. So for a student who's experiencing truancy for, as Paige is discussing, a whole host of other reasons, right? A whole host of other ACEs, right? Adverse childhood experiences, and the responses on behalf of the school are not affirming, the responses are not holistic, they aren't within a multi-tiered system of support. It ultimately ends up meaning that both their mental health is being diminished, and then the ways in which something like connectedness or climate can actually increase protective health factors is also being impacted. So that's then from the long view, right? So it's not just in the moment that their mental health is being impacted, but then from a long-term view, the ways in which not having height levels of protective health factors means that you're also going to see a disengagement even in the classroom and academic academic performance, increasing our risk of push out or dropout, but then also just thinking about what are the symptomologies around distress, what are the symptomologies that are then leading to a whole host of other system involvements. So again, it's that point of what's the dose effect and how and why education can serve in this co-influential nature where, you know, if you're in a healthy school environment, in the ideal healthy school environment, you're getting access to services, you're being treated with a level of dignity, respect, and ultimately cared for, right? That element of school connectedness, which is the second highest protective factor when we think about health protective factors for youth, then you have the opportunity to thrive and engage in the context of the school system.
What's our next question? You see, so Frank McCollum had his hand raised. I don't know. Somebody here in the audience.
Curious, aren't there cities and school districts, regional districts that they can point to basically moved entirely to a solution pay or state fund system that has eliminated all this traumatic, police interference and disciplinary interference in schools? Or is it a generally police situation with no bright line?
So the question from Scott, and I'm not going to repeat, but basically he asked whether you've seen something positive happen in the school context in terms of ability to pay programs for fines and fees.
That's the school context.
I mean, not the school context.
The whole thing, where's the good news?
Where's the good news? So he's saying where's the good news on fines and fees? And not just in the school context. And maybe one thing that I can kind of add on to this, it's kind of a really depressing picture that has been painted because it's the reality that we live in. So just to kind of add on to what Scott's saying is he saying where's the right picture on the fines and fees? Are there successful examples? And I think to just broaden out the question to our panelists, what are some of the specific successful reforms or examples that you've seen address some of the problems that you all have raised?
But I don't have good news for you. So let me just say this though, I think we have to understand that like the whole revenue model for localities needs to be fixed, right? I mean, I try to tell students when I'm talking to them, every Supreme Court judge has 4 law clerks. Every federal court judge has 2 law clerks. Every state law judge has what? Maybe 1, maybe not. And municipal court judges don't have any, right? Similarly, I go to HHS and there are million staff, and then I go to the state health department and they're fewer, and then the local health department doesn't even have a data person for me to help them. We have a revenue problem in terms of the issues being really local and most of our revenue not being local. And so it's a major issue that's going to take a lot of thinking as far as how we generate local revenue or how federal revenue comes down. But right now, there has not been a good model that has been implemented largely that replaces those fines and fees revenue with other. And that's really the problem. But I look to my panelists to tell me if they know something else, but we don't know anything else.
Mm-hmm. Hi, this is Denise. I want to just echo what Kathleen said in terms of the, I guess, the lack of a really solid example right now to share. One of the things that we're doing at the National League of Cities is going deeper on our fines and fees work with cities. So the first cohort of cities that we worked with leading up to the end of last year looked at a broad set of fines and fees at the local level where cities did a very thorough assessment of these different fines and fees. And because they were looking at different ones, it was difficult to go very far in terms of really looking and testing different models, promising models. But one of the things that came out of that assessment and that work with cities is that there was a lot more that we could do around looking at ability to pay. So with funding from our funder, from the JP Morgan Chase Foundation, we're going to be launching another cohort with cities where we're going to be really focusing specifically on ability to pay and looking at different models across the country. Some of these models are going to be tackling fines and fees at the court level. And others might be just other promising ways based on research that we're seeing. And we're excited to do this work because we feel that trying to find a role for local governments in terms of the authority of the fines and fees that they can actually reform is a way forward that I think that cities are open to and willing to explore. I think the challenge has been dealing with issues between the state and the local government. I think that that's been a bit of a roadblock. And so the work that we're going to be doing is to try to figure out how to address some of those barriers. And we hope this time next year, we'll start to have some examples of ability to pay models that we can start to share with the public.
Well, oh.
All right, Mital, you want to go ahead?
Well, how the question was framed us in the chat is also some successes. So I just want to quickly bounce off Denise, where ability to pay is one option, and I think it's a really important one. But I think before you even get to ability to pay, you have to define what that is, right? And that's what at the municipal level, there's really a unique opportunity for elected officials, including, municipal court presiding judges, to really better understand with the community, collaborating with the community, which fines and fees need immediate reforms. This is a very complicated system, as we've seen from the presenters. You can go through education as an on-ramp, you can go through municipal utility or traffic tickets, you can go through housing, right? There's all these on-ramps. So really collaborating with your community and your residents is really important. And so I just wanted to uplift Durham, North Carolina, as part of our cohort, really identified dignity in the process of receiving support as really important. So that's like the first step, I think, and even ability to pay, right, is, and for them, these process reforms of changing language, what was things translated in, the reading level, how many people and departments you actually had to go through to receive their water hardship funds, which is like a fund set by the city, right, to support residents who need it for something as simple as water access, but how undignified it can be to have your water cut off and then not be able to shower, not be able to brush your teeth, right? And all these things that aren't necessarily seen when you're just a person higher up saying, well, something's not happening, we need to find it to deter this behavior, right? That's what a fine is for, is to deter behavior. But is it actually deterring behavior, or is it just pushing people into a place where they don't feel they trust the government or trust that entity to come to them for support, when from our point of view, right, that is a position of support. So just wanted to quickly uplift that, as communicating and collaborating with your residents is really important to even figuring out and defining ability to pay.
You had a question over there.
Well, I don't know, it's not a question, I wanted to make a statement, because my name is Ronald Hampton, and I'm from Washington, D.C. And surely my city is not shining example when it comes to the fines and ticket writing, because there's been information about how they're victimized, continue to victimize Black communities and poor communities when it comes to tickets and all that stuff. But I've been working in a program for 9 years now, where we work with families and students on eliminating the obstacle to choice. That families won't be victimized by that process, because, like I heard someone say here, that children want to go to school. Sometimes the reason they don't get to school or don't get to school on time is because they may be involved in other family duties and other responsibilities related to family. But clearly, our program is working and has been working on eliminating those obstacles so that students can get to school, to reduce the backside in terms of the criminalization of those kind of issues. And I know we've been brought up this issue, because I've worked with formerly incarcerated individuals who wanted to work in the schools. And DCPS has, you know, they've been slow to do those things, but there have been some instances where people has criminal record didn't prevent them from going to school. There was a time when that was certain, but now that's not so much the case now because DCPS is getting to deal with those issues about if a family member, and unfortunately, there's a huge percentage or significant percentage of people in our community, Black and red folk, who have been incarcerated. And so there was this statute about being a felon and then not being able to go into school to interact with your students as well as the activities of the school, which that is ludicrous, I think it's crazy, you know. And so they're beginning to deal with that. And I still don't think that it's perfect or near perfect, and it's not a shining example of what it should be, but at least there are people that are attempting to deal with it and reduce some of those obstacles and get families involved, but also more importantly, eliminate the obstacles that prevent young people from getting to school on time and deal with some of those side issues rather than talk about, you know, sending parents to court and all that other BS associated with government problems. Not family problems, but government. Those real people is that government don't know what the hell it is. That's the real people. And I'm honest, and that's what we set up to in this program out here. It just doesn't make sense. And we've seen it. We've seen the evidence result of what we've been doing and how it's impacting on.
Thank you so much for that comment. And I think you should be talking to ELC folks, right? Because it sounds like you've got some examples, successful examples, right, of dealing with the truancy issue, as well as some of this occupational licensing issues in terms of having a criminal record and having various employment. Well, one last thing, I mean, I think we have time for one more question. And I thought, just going off what folks have been saying, what's going to move these issues in terms of, you know, I know Mital referred to elected officials. I mean, is it about communities organizing in all these different spaces, right? Where you're talking about these different issues, how is change going to be effectuated? And so I'd like to ask a panelist maybe to comment on that and what they see it being, you know, who are the stakeholders who are going to make a difference? What has to move or what has to change for some of these issues for us to begin to start addressing some of these issues? So maybe we'll start on the screen. So maybe Mital and Denise, you want to go first?
Thank you. I'm not sure that I fully understood the question, but I think you're asking about stakeholders and their roles and who needs to be involved, if that's what you were asking. I mean, the work that we're doing, right? So the National League of Cities, we're an association. We're a member association, and our members are cities. And so the people who we're providing support to are elected officials, mayors, council members, city managers, et cetera, et cetera. And we work very closely with them and with their senior staff. And so when we think about who is involved, we have seen that there's a role for elected officials to play in this work because they bring a certain voice to the table. They're champions, right? And so when they kind of rally behind an issue, it gets a certain level of attention that others don't garner. So they are champions, and then through their support, the city has a role as a convener, and they can bring a lot of stakeholders together. So we try to root the voice of the city and elected officials in our work to bring as many people to the table as possible. But elected officials and cities can't do it by themselves, right? So the role of community organizations is critical in many ways. For one, they validate the issue and the problem. So when we're looking at fines and fees, it's the community organization that is saying, yes, this is really truly an issue for residents in your city. And so that communication, that engagement is critical. And then that community organization brings expertise, knowledge, a number of things. They bring capacity, they can help to bring implementation supports. So lots of things that the community organization also brings. The role of the resident is critical here as well. And so Mital talked about the city of Durham, and one of the promising ways that they actually were able to not only understand the issue of the water debt in their city, but to start to design the interventions based on interviews that they were doing with their residents. And so that's a critical piece, having the voice of the resident at the table as well. So we feel that all of these partners need to come together, and it doesn't happen overnight. It takes time. And then you throw the pandemic into that as well. So we found that cities had to work differently and then do this in a virtual environment. So let me just stop right there and see if Mital, if you wanted to add anything else, and then to see if some of our other panelists want to share their thoughts.
I think you covered it all. Thank you, Denise. I'll pass it on to the next person.
So I'm happy to jump in with Paige and thinking about the schoolwork. You know, there's actually some really interesting things that are going on right now, but then I would say parallel to that are some incredible opportunities for increased change. You know, I think that, you know, both COVID-19 and racial reckonings around the continued trauma and death within Black communities at the hands of police has opened up some opportunities to talk about the ways in which racism is a public health crisis. And the reason that I bring that to the forefront is that there's actually been a move both to the point of thinking about Denise is making, is that at the city level, at the county level, at the state level, to actually pass declarations and resolutions that racism is a public health crisis. And while many of those name education, very specific, so there's more than 200 of those. So if you're interested, the American Public Health Association actually has a collected database that you can go search. So we've coded those, and education is listed in almost all of them as a particular area that's focused, but just listing it is not enough. And so this is both the opportunity, but a place where we're starting to see movement. Local school districts, and it's not just on the coast, I will say, have started to then operationalize those. So, and pass even stronger language around the resolutions. So you have resolutions that'll now prioritize the health of all Black people and and people of color within the context of dismantling systemic racism and trauma. And I'll read very specifically, in a school climate where the emotional psychological harm from exposure to criminalizing practice in schools is disproportionately impacting students of color. And then parallel to that, revisions to a discipline policy. The same thing that we've seen in terms of removing police from schools. Now that's a haphazard approach. Right now, there's really only 2 districts in the country that have actually removed police officers from schools and not just immediately replaced them with another form of policing in private security guards and in other ways. But again, it's this moment where through a public health lens, and there's been a really clear understanding that we need to prioritize something different. The same is true in the movement around reducing suspensions, expulsions, and explicit exclusionary and punitive discipline by approaching it through restorative models. And so that's something that we've seen over the last couple decades that there's been an increase in. But again, that spot of opportunity. When you look across the states, you know, 32 states and the District of Columbia still have significant legislation around exclusionary school discipline. And then the rest of the states very much have exclusionary school discipline language that's incredibly punitive and hasn't been even sort of reframed or thought about being transformed or dismantled. And you compare that to only 21 states plus the District of Columbia that have restorative justice laws. So again, a place of opportunity and growth. So we're seeing movement on some of these issues, but we're not seeing the totality of what the movement is. And so to the last point, and to Denise's, which I think is the second embedded question, like what's the opportunity for all of us to be seeing ourselves in this work and coming forward? I mean, it's 3 things. 1, it's prioritizing frontline communities. How and where do we think about what those interventions are, whether it's a moratorium on discipline, for example, which I know I've called for in previous symposia that Paige and I have been in, or it's thinking about engaging frontline communities in the actual decision making. So how and where are we thinking about the funding and the approaches that exist and the allocation from budgets away from policing or other exclusionary practices into investing them into responsive and community-driven practices, but also then that training of the next generation of advocates. I mean, I think that's an essential element, and I don't just say that because we're speaking in a law school context, but there's a really critical gap there that that lawyers, health and public health officials, in collaboration with frontline communities, really can identify not just what are the legal needs, but what's the comprehensive approach to address the health harming legal needs of those that are most vulnerable. So, you know, maybe it's thinking about, well, how and where, and this is the example coming out of poverty law, how and where do public benefits mitigate the negative health effects associated with housing insecurity, and then that co-occurrence with school discipline. The problem is we just haven't seen that next layer of, well, what is the co-occurrence with school discipline? But Paige, thinking specifically to some of the laws that you've elevated, I don't know if you want to talk about either opportunities or where you've seen present movement.
Sure, I can address this briefly. So we have 500 school, I'm sorry.
We're kind of running over, so if you made it really short, that'd be great.
Absolutely. So we have 500 school districts in Pennsylvania, which means we have 500 different districts that could choose to do things differently today. They could stop having officers. The Department of Education could eliminate the ability for folks to use police and residency investigations. Schools could stop banning parents. I know that legal change is needed to make that codified and make it an obligation, but if we eliminate these tools at a school level, they could choose to do it today. So Thalia, I will follow your lead and call for it now that schools, if you're listening, you could do it today. We'd be all better off for it.
It doesn't need either more crises or more leadership or both. We definitely would very much help the National League of Cities, the study that you're talking about. The revenue issue at the local level is extreme. And unless we have better models for that, we're not going to be able to figure out these fines and fees issues. So we have to deal with that up front. Crises may help, and leadership absolutely is essential on these issues.
I guess my quick answer to that is everyone at every different level. So basically, obviously, this is all, like I said, and I kind of emphasize that this is PHA's rules are set locally, so there's transfer local impact on local level, but also organization from within people in PHA housing as well, so that way what is done and is implemented is led by those who are impacted by it. Great, all right. Thanks so much to all our fabulous panelists. It's what I do right now.